Good afternoon, Judge Shapiro. I just wanted to let you know that we have representatives for both sides as well as the court reporter that I can bring in whenever you're ready.
Morgan, I'm ready to proceed.
Okay, I'll bring them right.
Thank you. Good morning. Good afternoon, I should say.
Yeah, let's not start over, Your Honor. Good morning, or I'm sorry, good afternoon. Christian Hauser on behalf of the plaintiffs. How are you?
Very good, thank you. Hang on, I got a little problem here on my screen.
Sure.
Let me figure it out. Okay. Good morning, Mr. Hauser, and Mr. Walden, you are here for the state?
That's correct.
Or do I have to say? Okay, very good. All right, well, Mr. Walden, it's your motion, so let me just call the case. It's Dan's Excavating, Inc. and Spartan Specialties Limited versus Michigan Department of Transportation and State of Michigan, Court of Claims number 22-191. And we are here today on the defendant's motion for summary disposition. All right, Mr. Walden, go ahead.
Thank you, Your Honor. May it please the court, Aaron J. Walden, Attorney General, on behalf of the defendants, the Michigan Department of Transportation and the state of Michigan, collectively on that. Your case, Your Honor, this case involves a contract involving construction work on I-94 in Jackson County. The contract is governed by MDOT's 2012 standard specifications and a DRB special provision. The DRB special provision creates a dispute review board, which is an independent, objective, impartial panel to hear escalated contractor claims. The DRB panel is composed of 3 members. Dan's Excavating Incorporated selected 1 member, MDOT selected 1 member, and then the 2 members selected the chair of the DRB panel. And all panelists were concurred by DEI and MDOT. Plaintiff Spartan Specialties was a subcontractor on this contract, and it was specifically to perform grout mining work. So that involved hole drilling, grouting, and testing. A dispute arose about the quantity of grout levels.
Although I don't need to know it, but I got to tell you, I have the slightest idea what the grout mine stuff is, but I know it's relevant to the legal issue.
So,
I trust it.
Basically, what happened, there were these old coal mines, Your Honor. And when we think of mines, you may think of, very deep mines, but some of them were as small as like 3 or 4 feet deep. So basically, in order to properly lay the bridge and the highway, we have to fill those. So that's the whole process is
Okay.
filling them. Yeah. So not to get too specific, but that's what was going on. So there was a dispute over the grouting quantities. So DEI at Spartan's direction brought those claims to MDOT's attention. Those claims eventually arose to a DRB hearing. After that hearing, a recommendation for non-entitlement for the claims was issued by the DRB. After that, DEI at Spartan's direction appealed that, and a DRB appeal hearing was commenced. After that, a DRB appeal hearing recommendation was issued on November 30th, 2020, again stating non-entitlement for the claims. And on November 30th, both DEI and MDOT was sent that recommendation by the DRB chair via email. So that's just a brief summation of the facts.
I understand.
So for MDOT's motion, there's 3 parts to it. The first is that because DEI accepted the DRB appeal hearing recommendation, the claims in this lawsuit are barred. So under the DRB procedures, within 5 business days after that recommendation is received, both—
Counsel, I just didn't hit, you said because DEI accepted, you said, so the claims here are
barred, cannot be had. Yep.
Okay.
So under the DRB procedures, MDOT's engineer and the contractor must send an acceptance or a rejection of the DRB hearing recommendation. So they have to either accept or reject that recommendation and send that to the other party and copy the DRB chair. Neither party in this case did that. So by the terms of the DRB procedures, the recommendation of non-entitlement was fully accepted by both parties. On December 15th, 2020, the DRB chair asked for a status of the claims, and that is when MDOT's engineer indicated that since neither party had timely responded, they had accepted the claims, or they had accepted the recommendation, I should say, for non-entitlement of the claims. DEI, who was copied on that December 15th email exchange.
Hold 1 second, if you would. December 16, right?
December 15th, I believe.
December 15th. Okay, I'm just pulling that here.
Yeah. So that was 11 business days after the November.
Yeah. All right, and the response, it looks like Mr. Friend, the chair of the DRB, sent that to the state's representative. Did he send it also to Mr. Yeah, he sent it to DEI, and doesn't look like he sent it to Mr. Is it Stevenson? I forget. Marinowski. But okay, continue. I understand. By then, the horse was out of the barn, according to you, anyway.
Yep. So under the DRB procedures and the standard specifications, this acceptance constituted settlement of the claims and barred the claims from being instigated in this lawsuit. So that's why we asked, the first part of our motion is under NCR 2-116C7, that these claims be dismissed because they had been released and there was another disposition of the claims. And I'm more than happy to stop here, or if you want me to go on to the other two parts, they're pretty brief.
No, go ahead and finish.
So second, under MDOT standard specifications, Spartan is barred from bringing any claims directly against MDOT. So there's no dispute that the contract is governed by the standard specifications. Under standard specification 104.10, any claim against MDOT for extra compensation must be brought by the contractor. In this case,
but in this case, it was brought by the subcontractor, and you accepted it.
In this case, Spartan sent it to DEI, and then DEI sent it to MDOT. So that's how it was supposed to go. At all times, DEI was actually the party in interest here. Spartan, again, maybe a third-party beneficiary, but at the end of the day, the party in interest is DEI. And standard specification 108.01, that specifically indicates that any contractor must bring claims against the contractor or the other responsible party. It cannot bring claims against MDOT. And that's if you saw, I believe it was Exhibit 9, the unpublished per curiam Court of Appeals opinion that very briefly just kind of talked about the effect of standard specification 108.01 and basically said that this bars any subcontractor claims against MDOT.
1 second, I'm just looking at 108.01. I'm trying to determine what was the salient portion here of this one.
It's on page 72, Your Honor. It's the first full paragraph. No subcontractor or supplier.
I see. Very good. I got it. Thanks.
Okay. The third aspect of MDOT's motion for summary disposition is, as a matter of law, DEI and Spartan's claims for unjust enrichment must be dismissed because express contracts cover the subject matter of these claims. It's well settled law in Michigan that when there's an express contract that covers the claims, recovery under the theory of unjust enrichment is improper. And I don't think there's any dispute here about DEI and MDOT having an express contract. As for Spartan, MDOT relies on the Holding and Landstar Express v. Next Tier, where the Court of Appeals held that when two parties have different contracts with the same third party, as long as those contracts cover the subject matter of the claims, unjust enrichment is improper for those claims. So that's why we would ask that this court grant our motion under MCR 2.116C8 for failure to state a claim.
Very good. Thank you. All right. You, of course, will get some rebuttal, Mr. Hauser.
Good afternoon, Your Honor. Christian Hauser again on behalf of the plaintiff. So I'll take these kind of in the order that they were presented initially.
You know,
So
Mr. Hauser, I'm sorry to interrupt right off the bat, but you represent both of the plaintiffs.
I
Do they
do.
have, is there a conflict here? I mean, I'm not suggesting that you shouldn't be on both, but I mean, I don't know whether Spartan has contemplated a claim against DEI if they end up losing against the state. I just want to make sure that's on the table.
No, there's no conflict, Your Honor. And this is often what happens in these kinds of contracts is the general will assign the claim over to the subcontractor, either through a liquidation agreement or some other type of document. And that's exactly what's happened here, Your Honor. So
Wait, it assigned its claim in the Court of Claims?
I'm sorry, say that one more time.
DEI assigned the claim before the DRB or the Court of Claims case? I'm a little confused.
Well, they kind of go hand in hand when they're in the dispute resolution board process. You know, it's very informal. And so they're all working together. However, in order to file the lawsuit, my primary contact, my primary client is Spartan. But as Brother Counsel did indicate, the contract is with Dan's Excavating. So in order to assert that breach of contract claim, we have to have an assignment where Dan's assigns over that
You have
claim.
one?
Oh, yeah, absolutely, Your Honor. Yes.
When was the assignment entered into, if you know? I mean, before or after the decision of the DRB?
It would have been after the decision, but prior
Okay.
to the lawsuit being
Mhm.
filed. Yeah,
Gotcha. Okay, thanks. Now you can proceed with your regular argument.
no problem. Sure. So, what's going on informally, and I think I put this in my brief, back in 2019, long before the job had even been completed, we had provided notice. I think this is Exhibit 6, Your Honor, of my brief, is we had put them on notice. When I say them, the owner, that, hey, listen, please find Spartan Specialties notice of intent to file a claim. So this is back in 2019. And what we're really talking about here, Your Honor, is prejudice. And has MDOT been prejudiced by Spartan's failure to timely respond and reject this November 30th decision of the DRB? And I kind of look at it as the old case evaluation rule that we used to have. We still have case evaluation, but that non-acceptance is a rejection, right? And in this instance, it's kind of the opposite. But here you've got a situation where the MDOT rules say, unless you formally reject it, you implicitly accept it, which doesn't really make a whole lot of sense from a practical standpoint. But nevertheless, it would seem incredibly unreasonable for MDOT to think that we would have accepted that decision when it was essentially a rubber stamp of the September 28th hearing. But more importantly, they knew from day one what these claims were. They knew what was going on. So MDOT can't come back and say, oh, geez, we didn't know what this was about, or because you didn't accept or reject it within 5 days, therefore, we are at some disadvantage. That clearly didn't happen. When you look at the email that you referenced, Your Honor, when Brother Counsel was arguing, you were correct. It was not sent to Spartan. Okay, I went through there and looked in that email, and I couldn't find any address where it had been sent to anyone at Spartan. And in fact, Mr. Sorensen, on behalf of MDOT, references the same exact issue that I brought up in my response, is that Steve Marinowski was in a very, very bad car accident after the hearing, but before December 5th, which was the cutoff date. And he references, it says, Dave did mention that Steve was in a crash recently, which may be related to his lack of response. That's exactly what happened. And that's in his affidavit. That's attached as Exhibit 5 of our response, Your Honor. So it's not as though we deliberately didn't do it. It's not as though we thumbed our nose at the process, but there were super, intervening matters, frankly. And I don't want to.
The question that kind of, jumps out is, well, what about DEI?
Sure.
Why didn't they file something? I mean, they were the ultimate party in a sense.
And I think it's something that we have to look at in a sense in the big context, is that while DEI was the contract holder, okay, with MDOT, ultimately this was the subcontractor's claim. Okay, and I think that they have to have some type of balance there between what role's doing. And my hunch, frankly, Your Honor, is that Dan's Excavating probably had deferred to Spartan for the prosecution of the claim, and Dan's was, for lack of a better term, holding the door open so Spartan could go into MDOT's offices and make that argument.
But I mean, that informality, I mean, I guess the question is, on what legal basis does that informality trump what the contract says?
Sure. I think what we have to look at is, and I talk about this in my brief as well, is about the substantial performance or substantial compliance issue. And, you know, we've had these issues before with MDOT where they know what's going on. They actively engage in dialogue. They have these meetings. They know what the claim is about. And then they come back and say, well, you didn't stamp this on the second Tuesday of the fourth month when the sun was at the 40th degree. Okay. And so therefore your claim is denied. But it's like, wait a second. The whole purpose of these provisions is to give the owner notice of what's going on. And here, Your Honor, clearly MDOT cannot say with a straight face they didn't know what this claim was about, or they have somehow been prejudiced. It's a constructive notice from the standpoint, but actual notice from the concept of this has been going on for 2+ years. So to that extent, Your Honor, I am asking you to go beyond the four corners of that contract to an extent to say, hey, let's look at what was happening at that time. And let's
Well, I got to tell you,
Yeah.
I want to hear everything you have to say, but let me tell you where I'm hung up, which
Sure.
is if this was a case in which Spartan was to file a response and Mr. Maranowski had been in this terrible accident, you know, it would be difficult, but there might be some equitable grounds.
Yeah.
But here we have the contractor who was not in an accident, and I understand that he was kind of standing by holding the door, as you say, but the equities, assuming we can get to equities, are a whole lot thinner because there was someone who could have answered.
And I understand that. And I appreciate the distinction and where the court is going. But again, we have to recall who's the party here that has the claim. And the claim is the subcontractor. Now, you heard counsel say that the subcontractors can't present that claim pursuant to the contract and the specifications, but it doesn't mean that they can't advocate for themselves, that they can't have a table or a seat at the table and actually argue that. So I don't know, frankly, Your Honor, if it's really Dan Excavating's job to present that claim on behalf of Spartan. I think it's theirs. If this was Dan's claim alone, absolutely, I'd agree with Your Honor. But in this instance, they're just standing side by side, and the real party that has been damaged is Spartan. So I wanted to articulate the reasons why maybe that December 5th date had come and gone, but I think there's certainly reasons why it ought to be excused. I certainly believe that there's an equitable relief here that is warranted under these circumstances at this point in the proceedings.
What about that Court of Appeals decision, granted it's unpublished, that basically says, you know, forget about informality and how things were handled. If you don't have a mutual waiver in writing, that's the end.
I think that, again, if we look at MDOT's own language in their emails where they acknowledge that this accident took place that precluded him from responding on or before December 5th, I think that gets around it. I don't have, Your Honor, listen, I'm not going to pump your tires here.
Yeah.
I don't have an email that says everyone, hey, don't worry about it. But what I do have is obviously a course of conduct. And what I do have is an understanding of these parties that say, hey, this is how we're doing this. Okay. And, you know, we filed our notice of intent, no issues there. And even when you look at the substantive issues of our complaint, I disagree politely that the Dispute Resolution Board is a non-biased, impartial resolution board. I don't think it's any different from the COR, the Central Office Review, that we deal with these on from time to time as well. It's an MDOT board, okay? And at the end of the day, we're entitled to go before the court to see if Your Honor actually agrees or disagrees with the DRB, and that's why we're there. And as for the unjust enrichment, Your Honor, I'll regularly plead those in the alternative. I think Michigan case law allows that. But and this is where I may have been a little bit confused in counsel's brief. If he just wants to dismiss the quantum Merowit action and, I'll deal with the breach of contract, that's fine. This deals with extra contractual work and extra quantities that go outside the scope of the contract sometimes. So that's why we generally almost always plead it as an alternative remedy under the court rules. I hope that answered some of your questions. Well, frankly, I hope it answered all of your questions. So, but if you have any others, I'm happy to try and respond, Your Honor.
No, I don't think I have any other questions for you right now. Mr. Walden, you have anything else you want to?
Your Honor.
Other than the fact, let me just point out that no one is requiring MDOT to take this position. But, I understand the legal issue is one thing, whether or not ethically they should have understood that this fella deserved a break. Unfortunately, that's out of my hands, but I'll just note it.
Yeah, and Your Honor, I just wanted to quickly just mention, as you kind of alluded to, this is a contractual. Can you hear me, Your Honor?
Now I can, yes.
Sorry, I'll yell. So the issue here is a contractual matter. So we don't look at equity. It's not even unambiguous terms. It clearly states if they don't respond within 5 business days, then they fully accept it. And if DEI receives some type of word from Spartan that there was an auto accident, then they never asked MDOT for an extension of this time period. They never said, we're going to deny it and err on the side of caution here. So respectfully, Your Honor, we would ask that the contract be honored as it's written. And I disagree with Mr. Hauser in terms of the effect of the DRB, because the whole purpose of the DRB is to be an impartial body, and that's why DEI selects one member. And that's why the chair is selected by the DEI selected member and the MDOT selected member. And at all times, these have to be concurred by, and if they're not concurred by the parties, then there's, some MDOT involvement there. But my understanding is that DEI selected their member, MDOT selected their member, the 2 members selected Mr. Fine as the chair, and DEI and MDOT agreed here on those selections. So that's all, Your Honor, at this point.
Hang on one second. Actually, this is a question for you, Mr. Hauser. I mean, are there any other cases that have been issued, cases of record where this question of contractor, subcontractor, and DRB has been addressed, other than the one that's been submitted?
I've not been able to locate any. If the court would provide me a few extra days, I could try and dig something up, but it's kind of a very, very narrow issue, Your Honor. And
you don't have to. We'll do the research.
Thank you. All right. I appreciate that. So thank you to your clerk. Okay. So that's it. But
I don't think they'll do this one, but I'll take it.
Yeah, it's one of those things that frankly, I don't think it has a lot of case law to it. I don't know if Brother Counselor Scott, Aaron, if you've seen it a lot, but I frankly haven't in my experience.
Mr. Walden, are you aware of any other cases that are on point going either way?
No, Your Honor, but I've not done extensive research on it. So,
okay.
Yeah.
All right.
But
Well, I have the answers to my questions. Do either of you have anything else you want to add, or any other issues you want to, since we're all on TV here together today?
No, but I want to thank you very much for your time, and I appreciate you letting us do this remotely. It was very nice considering the weather. Thank you.
Oh, I'm glad to get that feedback, because I was thinking maybe I should start having people come in, but I figured when I was in practice, I would never want to drive an hour to make a 5-minute argument.
If I may, and I don't mean to hijack your conversation, but no, I think there's certainly a time and a place to be in court. You know what I'm saying? I think it helps in certain instances, but geographically, I mean, I'm in Detroit area, to come out there, no offense, Your Honor, but it's a long drive, and I think you were completely on point here. So I appreciate that. Thank you.
Okay, great. Thank you. And Mr. Walden, I guess you could walk over probably.
Yes, I could. It would be a little rainy today, but I could walk over.
Okay, very good. Well, I thank you both. It's an interesting question and very well presented argument. So if there's nothing else, we're concluded, and I'll sign off.
Okay. Thanks, Judge. Aaron, thanks. I'll talk
we'll
to you
get to an opinion, before too long, I hope.
Okay.
I've got a lot of these, but we're getting through them.
Wonderful. All right. Thanks, Aaron.
Okay, thanks.
I'll see you. Bye, guys.